Welcome to one of the most layered courtroom cases we've covered this year, State versus Jerry, Kyler McGee. What starts as a standard plea hearing quickly spirals into a web of dismissed charges, surprising disclosures, and a heartfelt plea for redemption. McGee isn't your average defendant. He's a biology graduate with a double minor and a young daughter, now standing before a judge fighting for probation. But will his past, his choices, and a bitter divorce derail his second chance? Stay with us because this courtroom session packs legal drama, emotional weight, and some jaw-dropping twists you don't want to miss.
Court is calling 2025 CR 000220, State versus Jerry Kyler McGee. Can I have parties announced for the record for the state? For the defense?
Ron Ross.
All right. Are you Mr. McGee?
Yes, ma'am.
All right. You entered a plea of guilty to count one. Count two was waived without objection. All right. Count two was waived without objection. The court found there was sufficient evidence to find you guilty. The court found you guilty. According to your plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state is opposed to your application for community supervision. They're taking in consideration 2024 CR 007651, 2024 AL 001409, and the following night magistrate numbers: 751980, 751981, 751982, 751983, and 751984. In this case, no PSI was.
Let's pause here for a quick breakdown. McGee pled guilty to count one, and count two was waived without objection, meaning the court only considered a single formal charge in sentencing. A PSI or pre-sentence investigation was also waived, which is unusual since it typically informs sentencing with deep background context. Instead, the court requested McGee's criminal history directly. These legal maneuvers suggest the defense wanted to move quickly, potentially to avoid further negative evidence being introduced. Risky move, especially with the state opposing probation and bringing in a list of prior offenses.
Prepared. Defense counsel waived PSI. The court reset it to give parties a chance to have witnesses present if they wanted to have witnesses present. There was no objection to the court requesting the defendant's criminal history. Is that correct, counsel?
That is correct. You actually gave us the option of a PSA or to go forward, and we're going to opt to go ahead and go forward.
All right. So state, you are opposed. Why are you opposed?
Well, it's on this week last year. It's resulted in what could reasonably describe as a crime rate. Not the worst crime rate that Bear County has ever experienced. Crime rate.
Just one moment. Excuse me, counsels. If y'all could step back, I'm trying to hear. Thank you. All right, counsel, you may continue. Right. So with regards to the cases that are being taken in consideration, were those offenses alleged to have been committed on different dates?
Some arose out of the same criminal episode. Some are actually not being taken into consideration. That's my mistake by the UUMP. Is being dismissed for missing witness. Property is being dismissed for missing witness. The PG2 1 to 4 is being dismissed for insufficient evidence because, as far as I can tell, the PG2 substance was not actually tested by the Bear County criminal investigation.
All right. So if you will tell me the cause numbers that are not being taken in consideration but are being dismissed for other reasons so that I can notate.
Start with X 751980.
Okay. Yes.
9975193.
Now here's where it gets complicated. Several charges identified by cause numbers are removed from consideration, either due to insufficient evidence or uncooperative witnesses. One particular charge, involving a PG2 substance, is dropped because the substance was never even tested. That's a huge miss for the prosecution. But don't get it twisted. 3 charges remain on the table, all stemming from the same February 18, 2024 incident. This cleanup of charges may look favorable, but it still paints a troubling pattern that the judge can't ignore.
Cause number 2024 CR 007651.
Mm-hmm.
And issue 2024 AL 001409 will be rejected. That is an at-large case. I spoke with the complainant in that case, and he is going to be making a positive.
All right, so the NIGHTMAC number that ends in 80, what is the reason for that dismissal?
Insufficient evidence.
And the NIGHTMAC number ending in 983?
Missing witness.
And the cause number, the 2024 cause number?
Missing.
And then the AL number is being rejected. So that, any objection to the court then changing the paperwork?
No objection.
All right, so what the court will do is the court will remove from the plea bargain agreement that 2024 CR 007651 was being taken in consideration. The court will remove 2024 AL 001409, NIGHTMAC number 751980, and NIGHTMAC number 751983. So then the items that will be, the offenses that will be taken in consideration are NIGHTMAC 751981, 751982, and 751984. So with regards to the offense that's being taken consideration ending in 81, what is the offense date on that one?
81 was, I've got February the 18th, 2024.
All right, and 82
Same date,
and 84?
same date.
All right. And then this, the instant case is October
31st.
31st, 2024.
Yes, ma'am.
All right, state, is there any other criminal history for Mr. McGee?
There is one prior offense. You'll give me a moment.
Yes.
Check the CIC.
All right, and what's the,
500 out of Green County. For adjudication, which he successfully.
all right, and what is the offense date on that? Or the conviction date?
Disposition date is March 31st of 2020.
All right,
And that is all of the prior criminal history which I'm here.
all right, and state, you may continue your argument. All right, defense?
Judge, may I ask my client some questions?
Yes. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hands.
Here's where things take an emotional turn. McGee, 33, educated, once working in medical sales, shares how his life unraveled after moving back to San Antonio. He's divorcing, separated from his child, and struggled to find a job. The judge asks, how does someone with his background spiral into repeated offenses? His answer, wrong crowd. It's a familiar story, but is it believable? What do you think? Is this a man down on his luck, or someone who knew exactly what he was doing? Let us know in the comments. Would you grant him probation?
State your name for the record.
Jerry Kyler McGee,
How old are you, Jerry?
33.
What kind of education do you have?
I have a bachelor's degree in biology and a double minor in mathematics and chemistry.
Okay. Have you, what is your work history?
I've worked for myself and then as well as a few different laboratories and medical sales companies here in town. And that's kind of what I specialize in.
Here in town, okay?
Yes, sir.
Have you lived here all your life?
No, sir. I came to San Antonio in 2015 to attend a master's degree program and as well as work.
Did you ever leave San Antonio?
I left San Antonio for 1 year. I went to Waco, Texas for 1 year.
When did you return?
When I returned is when, right about December of 2023.
About a year ago?
Yes, sir.
Okay, are you married?
Yes, sir.
When you went to Waco, did your wife go with you?
She did.
Do you have any children?
I have a daughter. She's about to be 2 years old.
Okay, and when you returned to San Antonio, did you return with your wife and your child?
I did not.
Why not?
We were getting a divorce.
And where does she live now?
She lives in West Texas.
Do you see your child
I do.
very often?
As often as I can.
Okay, when you returned to San Antonio, were you able to get a job?
No, I was having a tough time finding a job.
Did you have a place to stay when you moved here?
I did.
Okay, and so how did you get into, you've had several incidences here. Most of them are misdemeanors or they're state jail felonies, small things, but how did you get into doing three different instances? How did you get into that?
I've just fell into the wrong crowd, and I take full responsibility for my actions. I shouldn't have been hanging around the people that I was with, and committing the same crimes that I've been charged with. I was down on my luck. I couldn't find a job, and I was doing anything possible to do what I needed to do to make money.
This might be the most revealing moment of the hearing. McGee says, "I deserve probation," and the judge immediately challenges him on that. It's a key ethical question. Does someone who broke the law get to decide what they deserve? The judge pushes back hard, reminding everyone that the community deserves safety, not just second chances. And while McGee insists he has a good family, a strong will, and a plan, it's clear the court needs more than just words. This is where character meets consequence.
That was wrong of me, and but I know that I deserve probation, and I really know that I can take classes and do community service and be responsible about it. And I know it's something I can complete because I have done it before, and I know I can do it again. I hope the court will grant leniency on it for that.
And also a job, you need a job. Are you going to be able to get a job?
Yes, sir. Yeah. Yes.
One way or the other, you're going to have to work. If you can't get a job in your field, you're going to have to get a job.
Yes, sir. Yes,
You
sir.
willing to do that?
Yes, sir, I am.
You understand if you're given probation, you mess up, you come back, you're going to go to prison.
I do, and that will not happen.
Have you ever had probation except the one case 10 years ago? You ever had probation?
I've never been in trouble in my life.
You ever been to prison?
I've never been to prison, no, sir.
Never been to jail more than a few days on these cases?
No, sir. This is the longest time I've ever been in jail, a little over 3 months.
Yeah. What is the situation on your divorce with your wife? Has anybody filed?
Yes, filed. So we're currently, when I get out of here, it'll be finalized.
You're asking for probation.
I am asking for
understand?
probation, yes.
Probation's not easy.
I know it's not easy, but I am a strict man. I've decided this is not for me, and I understand that I can't complete it. I come from a great family. I've got a great backing behind me, a great family behind me, and I know it's something that I can complete with in a timely manner and complete it successfully very easily.
Judge, I would ask you to give him probation, and I'd like to point out that the cases that we're going
Oh,
forward
just one second. Do you have any questions? All right, I have a couple of questions.
Sure.
You said you deserve probation.
Yes, ma'am.
What does that mean? That you deserve probation?
I feel like it's something that I deserve. I have not. My past history has shown that I have not, committed crimes. My whole life.
I just find that sort of like a weird
No, I would
statement.
appreciate. It's probably a better word for it. Yes, ma'am.
Because
It's
people,
something I don't deserve. Yeah, I
because
give it
people
to you.
deserve, in Bear County, people deserve people not to commit crimes,
Yes,
right?
ma'am. Yes, ma'am.
All right, we're going to go off the record.
So, what's the takeaway from State versus McGee? We saw a defendant with a strong academic background, emotional baggage, and a complicated rap sheet plead for a second chance. The prosecution tried to stack prior offenses, but half were dismissed due to technicalities. The judge remained firm, digging into McGee's choices, motivations, and whether he could truly commit to rehabilitation. This case raises tough questions. Is education enough to offset criminal behavior? Can a clean past truly balance out a messy present? If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more geo-dropping courtroom breakdowns. Until next time, stay sharp, stay informed.